All right. Good evening, everyone. It's 6 o'clock, August 28th, 2024. This is the City Council work session. We have, well, first, let's do the Pledge of Allegiance and we'll discuss the agenda. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Renee, would you please call the roll?
Councilmember Frank Bankert.
Present.
Councilmember Lloyd Roberts.
Here.
Councilmember Kim Shaw Elliott.
Present.
Mayor Dave Gaddis.
Here.
City Manager Kyle Reefler
Here.
and City Attorney Randy Mora.
Present. Thank you, Renee. All right, we have one item on the agenda, which is to review and discuss the draft interlocal agreement with Bel Air Shore. What the first thing that I'd like to do before we get into this is I'd like to get the city attorney to remind us why we're doing this.
Thank you, Mr. Mayor. So this story starts, depending on how you choose to look at it, somewhere around 70 years ago, 21 years ago, or just a few months ago. I'm going to start from a few months ago. A few months ago, at the end of March, in my office, I received correspondence from the then town attorney for Bel Air Shore, the title being Ray, Bel Air Shore and Bel Air Beach Interlocal Agreement, and it went on to identify a series of purported disputes between the communities, one having to do with the recovery of attorney's fees in connection with litigation to which the city was not a party, and the other having to do with parking permits and the like. Once I had an opportunity to analyze the issue within a week or so, I attempted to reach out to their attorney and learned that the town attorney had separated from employment with their firm. They had a new attorney. But I did bring this to your attention in April. And as we talked about it in April, my recommendation to you was my request of you was to give us an opportunity as communities to see if we could find a solution. I'd already been in contact with their new town attorney, who was not taking a firm stance on the recovery of attorney's fees and was not and admitted that the issue of the parking dispute was a policy one that may be able to be reviewed in the context of the existing interlocal agreement. When I say this story could start 21 years ago, your last interlocal agreement with the current and operative interlocal agreement between the two communities dates to 2003. When I presented this, the general consensus direction of the body was, let's see if we can work this out. We can do better than the agreement we have. I don't think there was anybody who felt otherwise based on the statements made. Now, what better means, of course, the devil is in the details. And so what I committed to you was give me some time to talk to their attorney, to talk to your city manager, so I have a better understanding of operationally what is the dynamic between the two communities relative to these properties, to unwind some of the history. I also took that time to meet. I met with Member Bankert and a member of the public who had a keen interest or an acute interest in this issue. And I took the sum total of that feedback. And as I committed to do for you, I came back with a draft proposed interlocal agreement. It was in no way, when I presented to you last month, and I presented that to you in advance of the meeting last week, but also at the meeting last week for the first time publicly. And that has more to do with the fact that you are a governmental entity, and the only time I can talk to my client as a whole is in a public meeting. And so while I understand there was some umbrage, concern, reservation about the pace at which we were moving or how it had been presented, it was really an attempt at transparency to say, here it is. You just got it last week, but here it is for the public to see. Give me your feedback. Is this a good start? Do we need to, I was not seeking at the time, some kind of, blanket blessing of it, but rather some guidance and feedback, because I went with no real direction except let's do better. I did look at, again, the historical documents, which is reflected, and I provided those to you as I got them back in April and May. And so I set forth that draft in the draft I did, which, by the way, is stamped draft. You rarely see me do that. I wanted to make it very clear this is in no way something that the commission or council has minted or has gone anywhere else. This is just my work product for your review. So it's brief enough that if I may, I'd like to just briefly go through it to explain what it was I submitted substantively to you upon your request that I followed up. And I say that because often, especially in this job where there are so many action items, so unfortunately, sometimes things get lost in the ether of all the things we're committing to do in a year or a month. I wanted to make sure this was, I know that this is important enough to this community that it could not get lost in the milieu of tasks and budget seasons and the like. And so I ensured to present it. And so what you have before you is a proposed document that's 9 pages. It has not been approved by this council yet in any form. It has not been reviewed to my knowledge and approved in any or commented on in any way by the other community, Bella Shore. Their town attorney is aware of the document, but that's just an awareness of it as it is a public record. So with that, it begins with recitals that goes through the history of all the whereas clauses, and to the extent public records are available. There's one whereas clause where I'm still trying to get the exhibit for that from the historical records, but lays out what the history is of how we got here with the original plats and all of that, all the way down to in the deeds between private entities leading to public entities to special acts. And so then it begins by acknowledging that those are accurate. One of the things that came up in talking and listening to previous commentary on the issue, looking at other issues that have been going on in the beaches and how those legal disputes have been resolved or disputed, was, to me, it seemed like there may be issues here, not just with the one issue we could resolve is clearly identifying visibly what area we're talking about. I know there's been concerns about people policing the public beach as their own private property, not talking about public trust doctrine, but like saying this part of the beach that is very much part of the lot is their lot or otherwise. So trying to say, okay, let's eliminate the dispute. And so what it contemplates in paragraph 2 is that within 90 days of this draft, the town and the city agree to equally share the cost for a professional survey to mark geographic boundaries of each of those lots. I understand fully that there are existing maps, surveys, public documents we can use. My suggestion would be use those as a resource to perhaps narrow the process or expedite it, but that an independent survey may be worthwhile. And again, this is just a recommendation. It's not, I'm not saying you legally have to do this. If you think that's not a necessary expense because you folks live and know this community better, by all means, please tell me. And that's true of all this. I work for a majority of you, just give me your guidance. I work for you guys. The next is beach and bathing. It says the town in its role as trustee. Yes, ma'am.
Is it correct that if we have an easement for the lot, then it would be to whatever the median
High water line.
is, and that it's public beyond that? And therefore we'd have it from wherever this line is to the water?
You're saying taking the public trust doctrine in tandem with the easement, this should be public land through. I think that's probably an accurate interpretation of it as it relates to those. There's not some private property owner beyond the mean high water line, to my knowledge. I don't know if somebody would claim otherwise. I don't know that that would be a valid claim, but it would be a claim nonetheless. I say that to say as a lawyer, anybody can say so, and then we may have to litigate or resolve that. But I'm not aware of any reason why somebody would own the land beyond that between the Gulf and the land we're talking about as to these 3 lots.
And if that's true, then I might suggest that we incorporate the results of the survey. We agree now to incorporate the results of the survey as an addendum to the contract, and that we might even include a statement verifying that we do have the easement through to the water.
I think that's an interesting point, and I can definitely consider that. I would ask just procedurally, if I may, with your indulgence, I just want to get through all of them.
I apologize.
No apology necessary. It's your meeting, not mine. I want to get through all of it, and then I think that way it might be just at least get a full understanding of what's going on here.
I believe the Kirkby lots do clarify it's to the water.
I'm sorry.
The historical deeds actually state to the water. I don't remember the language specifically. I do have a lot of it excerpted in the whereas clauses. I don't have all of them here. I have provided the deeds to you, so we can look to that. Of course, if the deeds say so, then obviously that makes it even easier. But of course, the deeds can't give what is public land anyway, so it would almost be a redundancy possibly if it does say that. So it does contemplate a survey and demarcation with shared costs between the communities. And thematically, as you look through this document, what you're going to see is attempts to establish some kind of parity or equity. You can never really achieve that in earnest. But what this contemplates at least is, right now you have these historical documents that say we get to use this land for beach and bathing purposes. And one view of this would be to say, let's just stand on those documents, that's all we need. And while I agree that it sets forth a legal right, the contours of that right is what's created the disputes between these communities. So rather than continue to have piecemeal dispute by dispute, this is an attempt to provide a document that will provide some predictability and resolve preemptively, and in some cases, in a reactive state, some of the issues between you. And so that's how this goes through. And this was, again, drafted with input from the manager. Hey, what is an issue we have? Where are we spending money? What are the infrastructural concerns? Let's talk about them here so we don't have to fight about it in a lawsuit 5, 7 months or years from now. So the next one is beach and bathing. Again, it recognizes the, in its role as trustee, set forth in legislative enactments, the deeded right and ability for the property owners and residents of the city on the east side of Gulf Boulevard, located within the corporate limits of the town for beach and bathing purposes. The city's residents, property owners shall have the right to use the lots to the same extent in nature as residents and property owners in the town. So this was in listening and looking at some of the litigated issues before, one of the concerns was, this is our beach too, then we should get to use it in the same way you do. And to the extent the ordinances in Bel Air Shore don't reflect that, this is an attempt to memorialize that. And then it says that the town further agrees to present to its commission any ordinances or legislative enactments necessary to ensure its code remain in alignment. I would love to tell you that let's just put in language that they says they will eliminate any ordinances. I don't know that they can agree to bind themselves by contract to legislative determinations. And so we can go down that route, but what I'm trying to say is they'll put the ordinances before them, but I would never tell my commission, you are bound by contract to vote this way in a meeting, right? I would tell them, this is why this is being presented to you. This is consistent with other agreements we're making, and then let you still make your legislative decision. So that's why it's written in that language. The next one, and this was based in part on resident feedback and part on some operational concerns as well, is memorializing basically uninhibited pedestrian access to these lots without limitation. Absent a lawfully declared state of emergency, we will have access to the beach through the lots at any time, instead of having hours that they are closed to pedestrian access. Understanding the operational public health, safety, and welfare concerns about not allowing parking overnight in there, or people to bring cars at night and do whatever you do. It's one thing if you're walking down the beach, it's another to come and bring your vehicles. And so the concern was, I don't know what to memorialize the premise that pedestrians should have access. If you live in your home and you want to go because it's a full moon and you just want to walk through that lot to go look at on the beach, you should be able to do that. I don't care if it's midnight. And that's sort of trying to reflect that. And that was again a point of feedback I received as well from Member Banker that I thought was a salient point to address. The next is beach patrol and maintenance, and these are largely addressing some of the administrative concerns raised by management. Enforcement, the town is town land. I know if you go to the property appraiser's website, the land belongs to the town of Bel Air. It is within Bel Air Shore. It is within their corporate limits, not the city of Bel Air Beach. There is reference to Bel Air Beach on the property cards. That is to the plat, the historical platted names of those lots. So you'll see like Bel Air Beach, before Bel Air Beach was a town and Bel Air Shore was a town, the plat said, this is the Bel Air Beach Improvement District. There's, might be the Gulf Wind subsection, all these sorts of names. That's just the platted name, but the land is within the corporate limits unequivocally of the town.
I have to pause you on that. If you go to Pinellas County property appraiser under legal description,
Yes, sir.
I'm going on 6th Street, but you can go up the other two.
Yes, sir.
Bel Air Beach, what legal description? Bel Air Beach, Unit 1, Lot 20.
Right, that's the plat description, sir. But if you go up to the owner
Right.
and the property address, both of those are Bel Air Shore. It is in their corporate limits. The legal description is referencing the historical plat document. That's not referencing the corporation that is the city of Bel Air Beach.
But it doesn't the plat document give convey what the Kirkby deeds say, that these lots are the beneficiary of the owners of the east side of Gulf Boulevard?
Yeah, this is a situation where two things can be true. I think it is true that you have the deeded right. I'm saying the legal description is not what's giving you that right. The deed is giving you that right. The legal description just reflects the moniker given through the plat documents. The legal description is not reflecting what is given in the deed. The legal description is quite literally that. It is the description that we have given it as a matter of law, but the description is not conveying the right. The deed is the legal instrument conveying the right.
I'm confused. I know nobody pays taxes on these lots, so.
Yes, as they are
Legal
part of the
description.
town.
It's, the legal description is different from the owner. And the grantor of the easement,
Who's the owner?
Bel Air
grantor
Shore.
of the easement, and that is Bel Air Shore.
I don't know if
But
that's true.
prior, but that original, what he's saying is that original deed, Bel Air Shore didn't exist, so that name wasn't used. But the entity that conveyed that ended up being Bel Air Shore.
Bel Air Shores, before these lots were created, it was the town of Gulf. And when Bel Air Shores was created in the legislature, I think in 1955 or around there, they were granted the taking over as the trustee to the beneficiaries of the east side of Gulf Boulevard. That's my problem.
So historically, and again, you can look to the whereas clauses. In February 1948, Kirkby executed a conveyance to the Bel Air Beach Improvement District. In 1955, Florida legislature adopted Senate Bill 964, establishing the town of Bel Air as a successor to the Bel Air Beach Improvement District, and that the predecessor to the town of Bel Air Shore. So if you're tracking that chain of existence, it goes Bel Air Beach Improvement District, town of Bel Air, town of Bel Air Shore. So ultimately it flows to Bel Air Shore, but it has a responsibility. You still, that doesn't mean we're without, when we talk about property rights, forgive me, I have a slight injury here. When we talk about property rights in the law, we describe them as a bundle of sticks. You can not necessarily own property and still have one of the sticks in the bundle. So you still have, though Bel Air Shore owns the bundle as a whole, you still have the right to use one of the sticks in that bundle.
And I think,
That's what's at issue.
and what this issue in part addresses is regardless of who owns it, that piece of ground is within the geographic jurisdiction of Bel Air Shore.
Correct.
And they have the right to enforce their law
Their codes in their
in that
town.
space.
They do,
Yes.
so they can circumvent the plat or the Kirkby deeds.
That's not, no, sir. You're taking the statement.
Randy, you need to take a break.
Yes, if I could just have a moment, I need to
Okay, all right.
So the point I was making is there's a distinction between enforcing your codes and your codes being permitted to completely ignore any legal rights that they may affect. Those are two different things. You have the ability to pass and enforce codes in your jurisdiction. Nobody is saying that they have the unequivocal power to ignore the legal rights related to any land in their corporate testimony. Just in the same way that the city of Bel Air Beach can enforce its code in its city, but we can't go into your house and invade on all your private property rights. It's still your land.
Yeah, but the deeds are licensed to issue to the people of Bel Air Beach.
It's
You are
not,
the licensed holder.
I think what you're saying is not, I think the way that you're interpreting it is that no holds barred, we can do whatever we want to on that land. And that
I would
is,
say that.
that's not,
Yeah, I'm
it's
not
not
saying that.
realistic at all.
No, I'm not
It's,
saying,
it's saying that we have access to the beach on that lot. And I don't think there's any other deeded rights to us on that unless I'm,
well, read the whole 48 and 44 deeds, okay? It'll actually tell you what you can and cannot do on those lots.
Right, and this recognizes that, and I don't know that we're gonna resolve this, in this moment. I prefer the opportunity to continue to explain how this document contemplates the resolution of these issues, and we can decide you can decide as a council whether that's the direction you want to move in. I think it'll be a very, difficult proposition to sustain without challenge.
Well, hold on one second, all right?
Yes, sir.
Let me interrupt you here. Okay, Mr. Bankard, you've read through this entire thing. You know the entire history, and it sounds to me like your opinion has already been made on what you would like to do
Well,
with this.
my opinion,
Well, hold
Okay.
on. Let me
Don't-
ask a
all right,
question of you. Is this a waste of time?
I,
We have to reach.
I know, I understand,
A
but-
full majority.
my opinion is why would we grant these people 1 ounce of consideration when they've done nothing but stick it to us? We had fines, we used to control all the fines on those lots, okay, and we used that money to repave the lots. The two guys that were just cutting the lawn there today that I was talking to, we used that money. They just arbitrarily went in and took the fines. Now, you go back to the statutes of Florida saying that what a trustee is allowed to do. They're not allowed to make money off of it. They're making money off of our lots now by collecting fines. Go back to the sheriff's contract, I believe Article 12 doesn't give them any right to collect fines for the town. It all goes to the city.
Talk about parking fines?
Yes,
Okay, well, at least for this particular issue, I think what we're talking about is, let's say we tell City of Largo, you can come and sit on our back porch anytime you want. We've given them an easement, a right to do that. But that piece of ground, that porch is in our jurisdiction. And so our rules apply on top of that easement. So
but that's
You can
not what
come
these
and
lots
gather.
say. These lots are specific. These lots give you what you can't build a house on it. You can't even build a sewage place, treatment on these lots. That's how specific these lots are.
I think we're talking about two distinctly different.
No, I'm talking about a town that just arbitrarily does whatever they want and takes our license to use these lots and says, no, we're gonna change this.
So, okay, so let me interrupt you one more time, Mr. Bankard. So
I would give these people,
this document gives Bel Air Shore rights also. And it sounds to me like you really just want to stick it to them.
no, it sounds to me,
And that, and we don't want to come to a good, solid agreement that works for both communities.
I pleaded with Bel Air Shores and on the floor, it's on the record, let's work together. Let's work together. Let's work together, okay? It's going in this year and out the other one. Just last month, Mayor Bloom, when he was questioning Captain Reiner about the sheriff increase, said, we're gonna get rid of you because 99%, and I have this on a recording, 99% of the problems that we use the sheriff are is because of Bel Air Beach. 99% were the problems. Well, I go to those lots, not every day, but probably 2 or 3 days a week. I find people parked there with Bel Air Beach tags, but I find people parked there without Bel Air Beach tags. So who's causing the problems? Not the Bel Air Beach residents. Then I hear Commissioner
This document
Story.
seeks to address that, sir.
But then I hear Commissioner Story, we're gonna tear up the paving, we're gonna put in range finders and make sure people aren't sitting here, sitting there. You know what, this to them, all right, and that's what I meant. And I didn't give these people an ounce of consideration.
I think that's pretty clear in your policy stance, and as a policymaker, you're free to adopt that stance. My job for you is as a risk manager to attempt to provide you solutions. And so what I would say is, if we adopt as a community the stance of we give no quarter, we give not an inch, which is certainly a policy position. If we adopt that, we can fully expect to continue to have more of the same, if not worse, problems. And if we.
We're getting nothing but problems. We're getting residents that are being ticketed because they're parked after dark.
And I'm trying to solve that in this.
That's what I'm saying is we need to take them away from the trust, we need to remove them as a trustee. That's the solution.
You know, You're echoing what we've been hearing for the last 4 years. You're saying the same thing that Joe Manzo said, exactly. And you know, that's your opinion. That's your opinion, and that's his opinion. It may not necessarily be everyone else's, but my point is, if this is your stance and this is a waste of time, let's not waste everyone's time and go home.
Okay, but what I'm saying is, this council, I believe, does not have the right to negotiate and give away parts like this document gives Bel Air Shores. I'm a landowner, you're a landowner, you're a landowner, you're a landowner, okay? Bel Air Shores doesn't have the right to use these lots. It clearly says it in these deeds.
Well, actually, so the deed says that it's deeded to you for public beach and building purposes. Yes, sir, and that language is echoed here.
Mhm.
I did closely review the documents, and I really do. I want you to understand, as my client and as a human person, I appreciate your keen interest in this and your knowledge of this, and that's why I sat with you individually with a similarly interested resident to make sure I understood your concerns. And I looked over, you know, I reflected on what you said, and I tried to make sure that I reflected that in this draft. And I appreciate you saying like, well, it's still not, you're not there, and that's fine. That's totally fine. Nothing I saw in the deed says to the exclusion of. Nothing I see in the deed says you can use this and no one else. Or no one from this community. It gives you that right, but I don't know that it necessarily, as a matter of law, excludes others from that law.
So you're telling me that the public can park there?
I think parking is not really even addressed in you and I specifically I'm not sure if somebody, let's make it the simplest hypothetical possible. A vacationer is here from Ohio, so no resident. They're here from Ohio, they're in Clearwater Beach, and they're an ultra marathon runner or pedestrian or speed walker, and they walk all the way down from Clearwater Beach, and then they get to lot 66 or 21 or 43. I don't know that we have the ability to eject that person as a member of the public just because they are not a property owner east of Gulf Boulevard. I don't see anything in the documents that would be actionable.
I believe the public can walk on those lots. Okay?
But to that same end, aren't the residents of the town the public? You're saying we should not give the town any quarter, any use of this land. They have the same use. Now, to the extent they're using it for parking and otherwise, am I hearing your feedback as we shouldn't resolve this dispute, or we should resolve this dispute in a way that makes sure the town itself never parks any of its vehicles or that of any of its contractors, agents, or otherwise, in those lots ever again?
Randy, I put on the floor in those meetings, let's work together. Those lots are very seldom full with parking, okay? Even with construction workers. I was a construction worker. I would be glad to be able to park and walk to my work site, okay, with my
Yes, sir.
son, okay? But when you have a town that does nothing but stick it to you, why would we grant them any courtesy?
So there's a dissonance in what you're saying, sir, because what you're starting with is I've gone there and I've said, let's work together, right? And at some point in the past, not too distant past, in 2024, I know you went there and said, let's work together. And you had what felt like at least constructive conversations on an individual basis with even some of their officials. And because of actions that have been taken or statements that have been made by individuals in that time, you are now at a point of, you no longer, what I'm hearing is you no longer wish to, you said, I went to them, they made me mad, and now I no longer wish to have a meaningful discussion.
I always leave the door of opportunity open.
So,
Okay,
and hearing that, I would say the opportunity is starts with the document.
why haven't they presented us something? They had it, and I'm not against Mayor. They had a great mayor. Mayor Schmidt was a great guy. He wanted to work with everybody.
This is not productive to talk about why they didn't or why they did do something. I would like to recognize Mr. Roberts while we're here because he's had his hand raised for about
Thank you,
10
Mr. Mayor.
minutes.
I would like to echo what you previously said. Mr. Bankert has every right to take whatever stance he wants to take. I think a couple of times I've heard him say that he really doesn't even want to have an interlocal agreement. with Bel Air Shore, and that's fine. Again, that's, he can do that. But now we know that we need 4-0 on anything that we vote on as we stand today. And like you just referenced, Mr. Mayor, if this isn't going to happen because Mr. Banker doesn't want to really have an interlocal agreement with Bel Air Shores, then I, with you, I don't want to waste.
I want to have an interlocal, I never said I don't want to have an interlocal agreement. I want to have an interlocal agreement that the beneficiaries of the east side of Gulf Boulevard are awarded their rights and they're not completely arbitrarily removed going down the road, which they have been in the last 10 years that I've lived here.
Okay.
Can I suggest just this, that we all recognize your concern, and it seems to stem largely from parking issues and things like that. But let's just walk through this and understand.
Kim, I don't know how
what
often you use the beach. I use the beach frequently, okay? And I've had residents that came to this hall before I was on council, went to Lynn Reeves. I don't know if you were around. They're sitting on my property. Okay, this is before Hermine came.
Yeah, I remember,
Okay,
yeah.
and then you had the jackass that put the sign up on this wall saying you're not allowed to sit here. All right, this is the mindset.
I know,
Okay?
I understand.
And until that mindset's removed, I don't want to do anything with it.
Well, if we can recognize your opposition to any agreement at all, can you listen to what is at least
I'm
proposed?
always willing to
And
listen.
then we can talk through. But we now recognize we have the potential of a stalemate here. But we'd like to walk through this, understand what Randy has developed. I think we all have some input and some suggestions for the agreement, and let's just kind of walk through it and see if we can get to a point of
I'm
agreement.
just saying, if this council gives up one piece of those Kirkby deeds, there'll probably be a suit.
I'll go even better. I think if we do anything on this issue, we're probably likely to see litigation. I think that the parties, that there are parties on both sides of this issue who feel very strongly. I think even in the absence of action, we're likely to see litigation because of the disputes that are arising and whether one person perceives the deed granting a right for the use, to use the same for beach purposes or beach and bathing purposes, depending on which lot you're looking at. I think that the ambiguities that language leads itself, that a void sufficient to be filled by litigation at some point. And we've already seen some of that. And unfortunately, for whatever series of reasons, the last set of litigation did not definitively resolve that. And so the question stands. I work for you guys. You guys just tell me what you want to do tonight.
Well, I'm looking for consensus. Do we keep hashing through this, or is this a waste of time and let's go home? Because I do not want to hit a brick wall every 5 seconds while we're going through this about how we're getting screwed. I'm just over it. And I understand that there's hard feelings in both communities. And what we're trying to do, the whole purpose of this document was try to put that behind us and move forward with a fresh start. And if the community is not willing to do that, or even one member of the council is not willing to do that, this is a total wasted exercise, and I'm not wasting my time doing it. If it's that hopeless, then I don't want to be here. So I would like to find common ground on this council, because we generally work well together, and I know that this is a sore subject. So, Mr. Banker, I'm going to let you decide what we do with this meeting.
I would like to proceed with an avenue of maybe Randy removing or taking legal action, removing them as the trustee. How hard would that be?
I'm going to start with hard, just as it's not a thing that happens often. What that looks like, I've never once researched into that. That's a different kind of action. But I can tell you, I have researched this. If we were to bring suit against Bel Air Shore, there is a specific statute for interlocal governmental litigation and disputes. That statute requires us first to have a series of meetings, and there's a whole process of what's noticed and on what timelines A, B, and C have to happen before you ever get to an actual lawsuit. And I can provide you subsequent to this meeting research on that if that's the interest of the body of what happens. The reality is you're whether by action or inaction, it appears we're headed in that direction as an event horizon. So I can tell you statutorily, we would have to have joint meetings between both bodies where we discuss this. We have to have good faith discussions. I'm trying to remember if it has an arbitration element to it, as there like you see in Fluidra and other dispute resolution statutes. But suffice to say, there's a specific statute. We would have to go through several hearings before we could ever just file. So we could not run to the courthouse tomorrow.
And so obviously, a lawsuit like that would draw a lot of public attention to both communities. It would make it all the way to the state level. Do you agree?
Absolutely. I mean, yes, and we'd have to report to certain state entities the existence, I believe, and don't quote me because it's been a while since I've looked at the statute, but I believe we have to tell DOR or somebody else. But yes, I think it would be a high profile item. It's not common that communities sue each other. Usually we're able to find some kind of solution. And I can, I think in our current landscape where there's certainly, and this is purely speculation, just observing as somebody whose entire livelihood is in this political realm, I think in the current socio-political environment where you're seeing efforts at the legislature, they're doing studies about dissolving communities in Manatee County, beach communities. A former mayor of a city here in Pinellas County wrote an op-ed piece about how there's too many cities on the beaches, we need to get rid of some. And I think the inability for two cities to resolve a dispute would contribute to that narrative. I'm not saying that's not reason to do it, but I think it would contribute to that narrative and certainly draw some ire that way. But that's just. I had a meeting last night in another community on a very contentious issue, and I feel the need to say this now to get ahead of a narrative that emerged there. My job for you is I'm a risk manager. That's really all I am. I don't know, insurance agent, whatever. I'm a risk manager. I look at a map and tell you, I used the same parlance last night, here be dragons. Some of you are prepared to slay dragons. Some of you would rather find a route around them. Some of you would rather go to the other side of the map. That's your risk tolerance. And as policymakers, you guys are asked to find some kind of collective risk tolerance. I work for you, you tell me what to do. When I tell you things like, hey, there's an emerging narrative out there that's this. I'm not telling you don't do it because of that. I would hate for my clients to make a decision from a place without information. As much information as I can give you, that's what I seek to do. So the moment I started researching this and got all the deeds and everything in one place, I said, here you go. You're my client, here's the information. I'm not the filter, I'm not your preacher and pastor who tells you these are the sacred words and you must listen to me. Here it is, reach your own conclusions. And so that's my aim. I'm not trying to prolong your time here with my little speech, but I do wish to your point, Mayor, yes, I think it would raise our profile and long before we ever got to the steps of the courthouse. If we did get there, that was the political will of the body. I don't know, I could speak ad nauseum and speculation and my perception of this, but my perception is not what's important, it's yours. So we're here to hear you talk.
Go ahead.
Yeah, I've worked on more than a couple interlocal agreements, and I've never seen an interlocal agreement where one of the parties gets nothing from their perception. That it's all one-sided. So that never happens and probably never will happen. That's the purpose of an interlocal agreement. So if Mr. Bankert, like I said earlier, if he feels that way, that the other party we're attempting to work with should never receive one iota or anything of benefit, then we're wasting our time here.
Well, why would a trustee get anything?
I don't know. I'm just saying we're
That's
wasting our
not
time.
that's not what 736.0805 of the code says. I mean, they're allowed to get reasonable fees to administer, what do they administer? They break our balls.
This
I-
is supposed to fix a lot of your complaint, and you're not even getting to the first page of it.
I've read the whole document backwards, forwards. I don't see how it gets us anything because there's no fines or penalties in this thing.
Frank, but that's another issue. That's something that can be added if need be. That's part of the discussion. I, for one, have no interest, zero interest in discussing in any fashion litigation with our neighbors. We've been through enough of that. And it wasn't,
We haven't been through anything.
this city has been through some
The city
litigation.
has not been involved in a lawsuit.
Well, I don't want to be involved in anything discussing that.
Why?
Why? Because I think it's a waste of taxpayer money. I don't think it's in the interest of the city, and I don't, as a trustee and as a,
You're not a trustee, you're a beneficiary.
of the city funds.
Of the public trust,
of
remains under the
public
Florida
trust,
Constitution.
Yes, I don't want to spend money that way.
And that's all it takes is one person to say no, and it's not going to happen.
So exactly, so
Well,
I think that what we have here is a prior agreement that was pretty high level. We have a history of some activities that have caused some friction. We can deal with it in an agreement, and it's an agreement. That means two people, two sides come together and reach an agreement. That would be through the course of some negotiations, and it would be go through the course of somebody taking the initiative to present a reasonable and thoughtful proposal. And I think that's the stage that we're at right now, is to consider doing that. I have no interest in talking about litigation. I don't want to raise the specter of it with our neighbor. And I even question, Frank, what standing we would have to even challenge the trustee of another entity. I don't even understand how we'd get there. So what we have is a very competent lawyer who is trained and very skilled in municipal law, and that's what we have here. And I am very willing to listen to his counsel and his suggestions. I think he did a great job of coming up with a preliminary agreement, and we could hash through the terms. But I think it is irresponsible for us to do anything other than listen and talk about another course at this stage.
I would reference you to go back and look at the Florida statutes of trustee and beneficiary. And see what the trustee and beneficiaries are granted.
I know what
And
a
then-
trustee and a beneficiary
On land,
are. Probably, no, I'm not gonna comment further on that.
because I'm looking at it right here and I don't see how. You said that there's been disputes. What disputes have we raised? Have our people caused?
It doesn't matter. You've raised examples of disputes that concern you. It doesn't matter.
That were Bel Shores imposed on us.
That's what I'm saying. It doesn't matter. If there is a dispute between parties, reasonable people try to resolve them. It doesn't matter who started it. That's playground stuff.
Again, I've asked to have reasonable talks and work this out and they've done nothing.
But that's you individually. We are here as the city council.
Why do we go to them when they've caused the problems? Why do we go to them when they say 99% of their police activities is because of Bella Beach residents?
I think as reasonable
That's a
people.
statement by one council member.
He was the mayor.
But I'm just telling you, it's not a policy stance of the town. It's the statement of it.
You know what, the other two council members, and I like Tolbert, didn't say anything, say that, oh, you're completely wrong.
Okay.
Exact, story actually compounded it.
Understood.
They've done nothing but put roadblocks up.
I think there may be another option that will allow us to stand back right now. In that, and I've asked our legal counsel to look into it. If we have 5 members, And I believe we can select a new member based on the majority of the quorum who's at a meeting. That's what I believe now. I could be wrong, but I'm pretty sure that's the way it's stated.
I believe it's the majority of the council.
There's language in 2.06, I believe it's 2.07
That's
C.
if everybody.
That says an official action is a majority of the council. There's a language in 2.06 C that says a vacancy shall be filled by a majority. Pardon me. A majority of the remaining members of the council. I would like the opportunity, as that was not the issue presented tonight, to review those against the backdrop of the canons of statutory construction to see how they would best be harmonized. But though there's 2.06 C and 2.07 C. So I would just like to look to those two.
I would like
provisions.
your professional opinion on if that's possible. And until then, I don't really see a path forward with this tonight's agenda. In fact, I think maybe it's a good time to adjourn.
I have one issue, if I might raise it.
Sure.
I don't know how many of you are familiar with or have been following the development of the proposal to develop state parks. You're familiar with that in the news. So the department has proposed golf courses, luxury resorts, and pickleball courts in 9 of our state parks. The Tampa Bay beaches,
Big C,
pardon?
is it Big C?
Is that, I don't think Big C
No, it
has,
was
but
the
the
Tampa
Tampa
Bay
Bay Chamber of
Chamber.
Commerce has taken a position in opposition to those developments. I, for one, certainly value our state parks. I think pickleball is perfectly fine. I listen to one out my back window, all pickleball court all the time. I have no objection to it, and I think it's fine in city parks and county parks. I think golf courses have no part in our state parks, which by constitutional amendment are there to be preserved forever in a native state. So I think it's a critical issue for us and for us as Floridians and for this council as a member of this community. So I'm wondering if this is something anybody has any interest in. Is there a way that we can express our concerns?
No,
Share those
absolutely.
concerns?
Absolutely. There's nothing preventing us from drafting a resolution and sending a copy of it to the governor.
I would
There's
love that.
nothing wrong with that. If everyone agrees, it may be too soon because the meeting's next week, but
I don't believe that I'd have it. I mean, I don't believe that I'd have it ready for Wednesday.
Right.
I can,
I
I
will
will the
say,
governor made a statement today saying they're going to recede from that and go back to the drawing board.
yeah, I don't think that's going to happen. I just don't believe I know what he was thinking, but he wasn't thinking. And so, with all the blowback that's happened and all the media attention, and everyone screaming at the top of their lungs, I can't see it. But it doesn't hurt for us to do a resolution and we'll get it signed. If first off, does everybody agree?
Yeah.
You good with that? Okay. Mr. Mora, if you could.
I'll prep one and then I'll see if any of my colleagues have already been asked to do so, in which case that might expedite the process, but.
It'd be nice if,
Be great.
something was already out there,
Yeah.
but we could do a formal resolution and send it on. Anything else?
I thank you all.
This is no problem. This is the general business section. If not, this meeting is adjourned. All right?
Thank you.
Thank you.